Good morning, everybody. My name is Robin James, and I serve as the Development and Marketing Director for one of the 13 local area agencies on aging, which is M4A, or Middle Alabama Area Agency on Aging. And thank you so much for joining us this morning for our 1.5-hour CEU webinar. There was a lot of interest in this particular topic. Last year, this was one of the ideas or suggestions from a lot of our attendees. And so this morning, we're going to cover applications for nursing home Medicaid and Medicaid estate recovery. And our very special speaker this morning is Jan Neal. And Jan Neal with Jan Neal Law Firm out of Opelika is our M4A legal service provider. She is an elder law attorney with over 30 years experience. And for a lot of the attendees this morning that have been participating in our monthly CEU Take a Stand for Caregiver webinars, you know the wonderful job that Jan does with the presentations, and just a really great expert in all of these aging topics that we present. For those of you requiring a 1.5 CEU this morning, you will have to stay on for the duration of the webinar. We do have a report that generates to show how long individuals are on this webinar. So please just, sit back, relax, get you a cup of coffee or some cold water, and just go ahead and enjoy the webinar this morning. Our CEU provider is Carlette Smith. She is with HR Option Solutions, and there is her email address. And so we just want to recognize Carlette as well. I also want to recognize Jennifer Fuller. She is our RN supervisor and the project director for our PANDA Alzheimer's project for Shelby County. And she does a lot of technical support for the CEU. So Jennifer, thank you so much for your support. I just wanted to briefly go over the Alabama Aging Network. There are 13 local area agencies across Alabama. We operate in all 67 counties. And so our agency is just one of those 13. Every county in the country is represented by a AAA or local area agency. So rest assured, if you have a loved one, family member, a friend in any part of the country, they also have access to a local area agency. And so all of the AAA's overall mission is to help individuals actually age in place within the community. For M4A, we cover Blount, Chilton, Shelby, St. Clair, and Walker counties. And so you can see the map on your slide, on my slide there. And you can always go to the state website and you can get your local area agency on aging. Every AAA also has an Aging and Disability Resource Center, which serves as the single point of entry to all the long-term care support and services. And so what the ADRC specialists do, we assist older adults, people of any age with a disability, and caregivers. So any consumer can call and be screened for all the different programs and services available, as well as get connected to really good local resources. So these are some of the core programs. A lot of them are under the Title III Older Americans Act. So you can see we have caregiver support, medication assistance, Medicare and insurance counseling, legal assistance, which is what Jan Neal provides for our agency. We do a lot on elder abuse prevention, and we also have the Ombudsman program and the Medicaid waiver. And a lot of the local ombudsmen are on this webinar this morning, and I know that the state long-term care ombudsman, Virginia Bell's on as well, so welcome, Virginia. And the ombudsman serves as the advocate for a resident in a long-term care facility. So any long-term care facility across the state, you will see a poster with their picture. And so they really do a great job to advocate for all of the residents. So that just kind of goes hand in glove with the topic that we're going to cover this morning. The next two, we have these every a Tuesday of every month. And there was a very high demand for us to cover ethical concerns for medical providers. And our very own Carlette Smith, who is our CEU provider, will be presenting on that on May 16th. And then June 15th is actually World Elder Abuse Awareness Day. And Professor John Kraft will be presenting on protecting someone else's money. It's real easy for our agency. If you need to refer somebody, just go to m4a.org, and we have an electronic portal that you just click make a referral, and it might be a lot easier for you to do that from your phone. And then our ADRC specialist will contact that consumer and screen them and provide as much help as they can. So, and I'll show the survey at the last, and there's our contact information. Jan did pre-record her webinar this morning, but she is on to take questions at the end. And so I'm going to go ahead and stop sharing my screen right now.
Hi, I'm Jan Neal, and we're going to talk about the Medicaid application process for institutional coverage. I've provided you with my contact information, and I want you to feel free to get in touch with me if you think I can help you with any of these issues. I've also provided you with a link to our Facebook page and our website. You'll find a good bit of information there on the topic of Medicaid. These slides will be made available after the presentation through our SlideShare account and through our Facebook page. If you'll go to our SlideShare, or just go to SlideShare and search for Jan Neal, you'll find our page with a number of publications. This publication will be added there in the next day or two. In this presentation, we'll examine the following issues related to Alabama Medicaid application process: nursing home placement, medical income and resource eligibility for Medicaid, Medicaid transfer penalties, application mechanics, including care facility contract issues, post-eligibility concerns, and Medicaid estate recovery. In putting together this presentation, I wanted to provide a tool that you could reference concerning application for institutional Medicaid. I wanted to teach you how to spot issues that might be a problem, help you determine the issues where you need to get help, if it's something above and beyond what you currently understand, and help you avoid obvious mistakes that result in Medicaid ineligibility. I believe that one of the saddest things I see on a regular basis is that people will do things that they think are perfectly fine, that they're not trying to fraud anybody, they're not trying to get around Medicaid, but it ends up with the person being ineligible for Medicaid because they simply don't know what the regulations are. The first thing to understand is that state laws differ. Medicaid is a joint federal and state program, so there are some rules that every state must follow in order to be funded, but each state has significant leeway in administering its own individual program. You might find that resources count in one state and they don't count at all in another state. You'll find that the income limits may be different, and you'll find that states use a functional assessment tool that they use to determine if someone meets medical eligibility. That may vary from one state to another. The same is true for Medicaid estate recovery. Property that would be subject to Medicaid's claim for reimbursement for funds spent on a person's care might be protected in one state, but they would not be protected in another state. So it's really important to recognize that difference, and you can't rely on what you might have heard about a resident in another state. Even with issues that are federal requirements, you'll find that states interpret the federal law in differing ways, and that's why you see lawsuits against Medicaid whenever a claimant believes that the federal rules were not interpreted correctly. I believe that one of the most stressful events that a caregiver can go through is applying for Medicaid. I tell people all the time that it's a lot like feeling like you've been through an IRS audit because so much information is necessary. It's so hard to arrange for care to begin with. There are a lot of emotional issues involved, usually with a placement, but there's also the shock of learning the high cost of nursing home care. And it's hard to understand how to get governmental assistance through Medicaid. I believe that the other reason Medicaid applications are so hard is because the person who knows where all the documents are is now the person who is really ill and not able to help in locating the necessary information to provide to qualify for Medicaid. For one person to conduct business for another, there has to be documented authority to act, even in a lot of situations for one spouse to act for another. It's not at all unusual to see a person with no legal authority completing a Medicaid application, and that's fine until liquidating assets or providing a lien or establishing a Medicaid qualifying income trust becomes necessary. That person who had no legal authority now needs that legal authority. So for this reason, any person who may be at risk for nursing home placement needs to have a durable power of attorney established to name the agent to act for him or her if he or she cannot act independently. It all starts with finding a nursing home. And in order to compare the different facilities that are available in your area, you can start at the Alabama Public Health Database. I've given you a link to that database. And the Medicare.gov database can also be accessed, and I've given you a link to that. There's another source to locate nursing homes in your area, and that's at elderguide.com. Understand that for Medicaid to pay, a claimant must be in a facility certified to participate in the Medicaid program. If a facility accepts Medicaid for payment, then Medicaid's quality of care regulations apply to all the residents in that facility, even those privately paying. Something I've run across and don't hear much spoken about is special focus facilities. I'm not sure that the general public understands what a special focus facility is. The Centers for Medicare and Medicaid Services provide a list of special focus facilities on its website. These are nursing homes that have a history of serious quality issues or included in a special program to work toward improvement in their quality of care. As of March 16th of this year, CMS recorded one special focus facility in Alabama, Ahava Healthcare of Alabaster. And at the same time, they had a list of candidates, those facilities that are being considered as special focus facilities, but were not yet so designated. And that included Atala Health and Rehab in Atala, Diversicare of Foley, Diversicare of Pell City, Marywood Lodge in Elmore, and Village at Cook Springs Skilled Nursing Facility in Pell City. We need to briefly cover Medicare's role in payment for nursing home care, since many people are convinced that Medicare is really going to pay more than it will pay. Medicare will pay for the first 20 days of care in a nursing home if the patient has a 3-day prior hospitalization and is admitted to a nursing home within 30 days and requires skilled care. While the Medicare literature does indicate that Medicare pays for up to 100 days of nursing home care, in reality, if the patient continues to have skilled care ordered by a doctor, on day 21, a copayment of $185.50 per day begins and has to be paid all the way through those 100 days. There are some Medigap policies that will cover this copayment, but they are the more expensive plans, and I seldom run across people who have those. It is not at all unusual for people to think that Medicare will pay for long-term care. And I think it's important that they understand that Medicaid should really be their focus, since even if they get some Medicare coverage, it's very limited. People often think that an application can be submitted in advance of placement, but it can't. Some nursing homes do have potential residents complete a Medicaid application to screen for eligibility. This means that if they see someone who transferred a good deal of property within the last 5 years, they're afraid they're not going to be able to get that person to qualify for Medicaid. And in that event, they might not accept them as a patient. A Medicaid application cannot be approved until an applicant is institutionalized for 30 continuous days. And if the resident met all requirements for the preceding 3 months prior to the application being filed, retroactive eligibility for those months also may be established. The exception is an SSI recipient who is automatically eligible for nursing home Medicaid. There are occasional cases where a person dies before being institutionalized for 30 full days, and no Medicaid payment is ever made. Medicaid is the primary single insurer for long-term care in Alabama, covering roughly 65 to 75% of nursing home residents. According to Genworth, the median cost of nursing home care in Alabama in 2020 was $6,540 per month for a semi-private room and $6,911 for a private room. Now, understand that Medicaid will only pay for a semi-private room, but nursing home costs exceeded that in many areas of the state. But if you use the Genworth numbers, then last year in Alabama, a private pay resident paid $78,500 to $83,000 per year for nursing home care. Medicaid becomes an essential benefit when you realize that very few people can afford an extended stay in a nursing home at private pay rates. Alabama general eligibility requirements for nursing home Medicaid benefits require that a written application with Medicaid be filed on Form 204-205. And I've provided you a link to get that form online. There's also a form online that is fillable, and you can fill it out and then print it, and I've given you a link to that. You have to be a U.S. citizen or qualified resident alien. You have to be an Alabama resident. You have to have certified medical need for nursing home care, meet income eligibility requirements, and meet resource eligibility requirements. A claimant must be a resident of Alabama during the period covered by the application and must indicate intent to remain in Alabama. If incapable of stating intent, the state of residence is the state where the claimant is living. There's no waiting period to establish residency in Alabama to qualify for Medicaid benefits. If an applicant is a resident of Alabama, but their Medicaid has not terminated in another state, it does not prohibit them from applying for and being approved for Alabama Medicaid. It is the other state's responsibility to terminate their coverage. So it's every state for himself, I guess you'd say. The other state's failure to terminate will not prevent the applicant from having access to medical coverage and services in the state where they currently reside. The first hurdle is medical eligibility. To be medically eligible for Medicaid to pay for long-term care, a doctor must certify that nursing home care is required on a daily basis in a nursing facility on an inpatient basis and under the supervision of a RN and under the general direction of a physician. The nursing facility will submit the medical information to Medicaid. The Alabama Administrative Code lists specific services that a resident might require, 2 of which are needed for an initial admission. And I've given you a list of those services here. As you can see, they're pretty high level of care services. So a person will need to meet 2 of these requirements. I think a lot of times what you see is a person will have, they'll need assistance with one defined activity of daily living and then something more severe, or it could just be the eye drops or an oral medication, a routine administration of an oral routine medication, and then a more severe level of care needed for something else. Medicaid residents who are discharged to a hospital and have no break in institutional care since discharge from a nursing home, and residents readmitted in less than 30 days after being discharged into the community must meet only one of the service requirements, and persons admitted to a nursing facility as a private paid resident in spin down status with no break in institutional care for more than 30 days who become financially eligible for Medicaid only need one of the service requirements to be medically eligible for Medicaid to pay for nursing home services. To qualify for institutional Medicaid, the applicant must be financially eligible by meeting the limitations set for both income and resources. And it's important to distinguish between the two. Items received in cash or in kind during a month are counted as income. Items that are retained as of the first moment of the month following receipt are counted as resources. It's important to distinguish between these two so that you're applying the right rules to any given item. And an item cannot be counted as both income and a resource in the same month. Individual income of the applicant must be at or below $2,382 per month in 2021. For a married couple, the spouse's income is reportable, but it does not count. For Medicaid eligibility purposes, any income from most any source that a Medicaid applicant receives is counted. And I've given you some examples here of just regular old income from employment, rental, black lung, railroad retirement, Social Security, stock dividends, and so forth, alimony payments. There are some types of income that do not count. COVID-19 stimulus checks do not count as income. Another exception is VA aid and attendance, unusual medical expenses, continuing medical expenses, and housebound allowance. All of these types of VA benefits are not counted in the eligibility step of the budget process for all cases. So if a person's VA aid and attendance benefit push him or her over the income limit, a MQIT would not be necessary to establish eligibility. We'll talk about what that is in just a little bit. SSI does not count as income. An SSI recipient is automatically eligible for nursing home Medicaid when he or she meets the medical eligibility requirements. If they own a house, however, and it's been excluded because of eligibility as their home place through SSI, that property would need to be sold. Now, if countable income exceeds $2,382 a month, a Medicaid qualifying income trust known as an MQIT, or just referred to as QIT, will need to be established. Medicaid will not permit an applicant to refuse or decline income. If you refuse income or resources, that's treated as giving it away. And that's true of either income or assets. If you have the right to get them, you have to take them. However, the cost of living adjustment for the teacher retirement or state employees retirement pension plan is an exception to that rule. A person can refuse the cost of living increase if that increase negatively impacts Medicaid eligibility. Now, when a couple receives joint income like a rent check, the income is allocated between the husband and wife in proportion to that which each owns in the asset producing the income. So if a husband and wife own property 50-50 and a check comes rolling in, 50% of that is the wife's income and 50% is the husband's, regardless to whose name is on the check. But when there's no underlying asset involved and a check is received, then that income is attributed to the name on the check. That might be an example, could be where somebody gets a utility refund, or it could be a gift where a child has sent a check to the parents. If there's no underlying asset, then whose name is on the check is what Medicaid would consider for whose income it is. The MQIT is an irrevocable trust that is signed and a bank account opened in the name of the trust. the applicant's income is routed for direct deposit into that bank account. If it's established and funded properly, the applicant can have any amount of income over $2,382 without that being a bar to establishing eligibility for Medicaid. Now note that while a QIT will qualify a person for institutional Medicaid when he or she has income over the income limit, this type of trust cannot be used to qualify a person with excess income for home and community-based waiver services, a different type of Medicaid. Many banks do not understand the QIT, and some just refuse to open an account named for the trust. They hear the word trust and they can't wrap their heads around it. And they don't understand that all you're asking to do is to open a checking account and put the name of the trust on that account. Some banks will erroneously require the person opening the account to get an EIN, an employee identification number from the IRS, and that's not necessary either for a QIT. In some situations, when no local bank will open an account named for the QIT, Medicaid can designate a patient account at the facility to receive and disperse the QIT funds, but this is rare, since most locations will have one or two banks familiar with this type of account. And if you live in a large city, of course, you'll have multiple banks that can deal with the QIT. As an example, in Lee County, Bancorp South is good to work with in establishing a QIT. If the sum of income from both spouses exceeds the income limit, do not be concerned and create a QIT. Only the income of the applicant exceeding $2,382 results in the need for a QIT. Now, it's not necessary to route all sources of income into the QIT bank account. I think that sometimes it makes life a little easier if you do, and you have all the money attributable to the Medicaid recipient in one account, but you don't have to. It's only necessary to place enough funds into the QIT to bring the non-QIT income level below $2,382, the income limit. However, all income from any source determined to go into the QIT must be deposited into that account, because Medicaid will not exempt income that's only partially deposited into the QIT. As an example, an applicant has $1,900 Social Security and $700 in a pension for a total of $2,600. Either income source alone can be directed to the QIT to bring the non-QIT income total below $2,382. But if the Social Security is selected, all of it must be routed into the QIT. And if the pension income is selected, all of it must be routed to the QIT. Timing is important for establishing a QIT. It needs to be in place to receive income exceeding the income limit for any month the applicant requests coverage by Medicaid. Now, keep in mind that it can take 30 to 60 days for direct deposit changes to take effect. Now, if you've opened the new QIT account, don't close your old account until you're sure that the Social Security benefit or pension or whatever that's being directly deposited into another account has been rerouted to the QIT. For QIT purposes, if income does not get deposited to the new bank account named for the trust, and that often happens the first month the QIT is established, you must remove the exact amount of income received from the old account to the QIT account on the next business day. Now, remember that resources should never be placed in a QIT, and Alabama has a form 262. It's a packet, and it includes an acceptable trust form to create an MQIT, and I've given you a link to where you can find that form online. When Medicaid eligibility has been established, Medicaid figures a budget to determine the amount of income the nursing home resident must pay directly to the nursing home. This is your personal liability. After that amount is paid, Medicaid picks up the difference in that personal liability and the nursing home Medicaid rate for room and board. It's important to remember that during the time a Medicaid application is being considered, the resident should pay the estimated liability each month, because if you blow their income on something else, there's going to be this amount of money that they're still responsible to pay even after Medicaid eligibility is established. Medicaid will allow the resident to keep from their income the personal needs allowance of $30 per month, also an additional $90 if the resident is eligible for veterans benefits that are dropped to $90 after eligibility is established. The spousal minimum monthly maintenance needs allowance, which is enough money to bring the income of the spouse at home up to $2,155 a month. A family maintenance needs allowance, a similar allowance for minor or dependent adult children, a dependent parent or a dependent sibling of either spouse living in the home. Cost of necessary medical or remedial care not covered by a third party, like the Medicare Part B premium. And if liability amount is available after these deductions have been taken, then an offset for non-covered medical expenses can be given. These allowances are made to the extent the resident's income is high enough that they can be covered with that income. Let's look at the minimum monthly maintenance needs allowance. You'll see that written some places as the MMMNA. The spousal impoverishment rules allow the spouse remaining at home, the community spouse, to keep a portion of the institutionalized spouse's income, and both spouses have to agree to the allocation. This rule allows the community spouse to claim an amount up to $2,155 per month. I've given you an example of that. Let's say the wife's income is $1,200 and the husband's income is $2,500. He goes in the nursing home. A QIT will qualify him for Medicaid. The minimum monthly maintenance needs allowance of $2,155 is first taken, and you subtract out the wife's income of $1,200, and you see that the potential allocation for the wife is $955. The allocation can only be made if the institutionalized spouse's income is high enough to cover it from his income in calculating the personal liability. Now, this is something you don't run across very often, but I have seen this. Every now and then you'll see the spouse has enough money to pay for nursing home care. You see people with income up around $6,000 or $7,000, but the wife at home, her income may be a whole lot lower. It could still be beneficial for that person who has enough money to pay for nursing home care to apply for Medicaid with an MQIT, because that allows money to be sent home to the spouse with income less than $2,155 to bring that person up to that amount of income. And that can be beneficial for the spouse at home. The family monthly needs allowance is available also, and I have given you the calculation to determine how much the family allowance can be paid, up to what amount it can be paid. You don't run across this, like I said, very often, but you have the formula if you need it. And all of these allowances, sometimes there's just not enough money to cover all the allowances that you're trying to get. And so the spousal allowance comes first. Well, actually, the personal needs allowance comes first, and then the spousal allocation. Looking at resources, example of resources include cash and mortgages, the cash surrender value of life insurance when the face value exceeds $5,000, mutual funds, promissory notes, equity in real property, checking and savings accounts, stocks and bonds, loans, mineral and timber rights, and certificates of deposit, annuities, IRAs. It's important to understand that the first of the month rule requires that a resource determination be made as of the first moment of each calendar month and is applicable to the entire month. A claimant's countable resources on the first day of the month will be counted for the entire month. So if a claimant has excess resources on the first day of the month, he can't be eligible for Medicaid until the first day of the next month. And then only if the resources are at or below the resource limit on the first day of that month. Income received during the month that pushes a bank balance over $2,000 for part of the month will not be a problem as long as those funds are spent back down before the first day of the next month. Remember that funds can't be considered income and resources at the same time. So that excess in the bank balance is not a big deal because the money making it over $2,000 is income. And if that money is spent down before the first day of the next month, no problem. It is important to recognize that property held in a trust that allows the Medicaid applicant to access and use the property, it will count for eligibility purposes. The only way a trust can shield assets from being counted is for the trust to be irrevocable, established over 5 years prior to application, and for the assets to be unreachable by the applicant. Income only from the trust can be available to the applicant by the terms of the trust. Don't confuse this with a special needs trust, which is a different tool that can be used to set aside funds to pay for special needs for a disabled person. We'll talk about that in a bit. Many people think that property in a living trust will not be counted for Medicaid purposes, but it will count. A living trust is not irrevocable, and the person creating it has full access to all the assets held in the trust. If you can access resources, Medicaid counts those resources. Retirement funds do have to be liquidated in some, do not have to be liquidated in some states, but in Alabama, they do. Now we're going to look at some resource calculations. Countable resources must be at or below $2,000 to qualify for Medicaid. That's straightforward for a single person to determine whether or not he or she's currently eligible or whether they need to do a spend down. But for married persons, the calculation is more complicated because of the spousal impoverishment rules. These rules allow the community spouse remaining at home to keep some assets to meet his or her needs in the community. This is known as the Community Spouse Resource Allowance. You'll see that referred to as CSRA. In order to determine how much a spouse at home can preserve for himself or herself, a married person applying for Medicaid must provide an inventory of property the couple jointly and individually owned on the snapshot date. And the snapshot date is considered the date that the person first entered long-term care. And that could be when they went straight into a nursing home or when they went into the hospital. And from there, they went into a nursing home within 30 days without a break in institutional care. From those resources that existed on the snapshot date, the home is protected for the spouse if he or she continues to live there. Besides the home and a vehicle, the community spouse is allowed to keep the first $26,076. If joint assets exceed $52,152, the community spouse can keep 1/2 up to a limit of $130,380. It's important to understand that you use the allowance, the maximum allowance for the year that a person was institutionalized. So somebody might go in a nursing home in 1 year, but the next year they're applying, or 2 or 3 years down the road after spend down, they're applying for Medicaid. In that event, the amount the spouse at home can keep is determined by what that resource allowance was the year that the person went into the nursing home. After reserving what can be set aside for the spouse, all remaining funds over $2,000 plus the income of the applicant must be spent down to become eligible for Medicaid. Note that when a married couple are both institutionalized and both apply, each is treated as an individual rather than as a couple. And treatment as individuals begin on the first day of the month. Following the month, both are institutionalized. Spousal impoverishment rules won't apply, and an assessment of resources will not be conducted because each is evaluated as an individual applicant. Now, I've given you a sort of a spousal allocation in a nutshell, where you can see what we've just been talking about, but you can refer back to it quickly for information about what counts and how much the spouse at home can keep. I'm going to look at some examples of spousal resource allocation. In example 1, a couple has $20,000 in countable assets. The community spouse keeps $18,000 because you're going to take that $20,000 and you're going to give $2,000 and assign it to the institutional spouse as their resource allowance. And you're going to let the spouse at home keep the rest because it's underneath $26,076. So in this situation, the person applying for Medicaid would qualify without any spend down. In example 2, a couple has $40,000 in countable assets. One half is $20,000, but the spouse keeps the first $26,776. The applicant must then spend down the rest above $26,076 except for $2,000. When you get through doing the math, you go 40,000 minus 2676, that's 13,924, minus the 2,000 for the resource allowance. That leaves 11,924 that has to be spent down before qualifying for Medicaid. In example 3, a couple has $60,000 in countable assets. The community spouse keeps one half, which is $30,000. The applicant has to spend down the rest except for $2,000. So that would be an amount equal to $28,000 that would have to be spent down before the institutional spouse could qualify for Medicaid. And in example 4, a couple has $300,000 in countable assets. One half is $150,000. So the cap of $133.80 would apply. And that amount only is retained by the community spouse. The applicant spouse must spend down the rest except for $2,000. So that would be $300,000 minus $130,380 would leave $169,620 minus $2,000 for the resource allowance would leave $167,620 that the institutional spouse would need to spend down before qualifying for Medicaid. All resources, whether owned jointly or individually by either spouse, must be combined, beginning with the point that the spouse was institutionalized. Again, that's that snapshot date. This often means that people are reconstructing what resources they owned at an earlier date, and that can be rather confusing. Medicaid can perform an assessment if requested to provide the couple with written instructions on what the community spouse can keep and how much the institutionalized spouse must spend down. The assessment is supposed to be completed at the request of the institutionalized spouse or a community spouse, or a representative acting on behalf of either, or at the time of the application for Medicaid benefits. A copy of the assessment results is provided to each spouse, and a copy is retained for the case record. The agency uses, or used to use, a Form 230. It's hard to find. I've seen the form, but I can't find it online. In situations where the community spouse cannot be located or may be alleged to be deceased or refuses to cooperate with the institutionalized spouse, then that person applying for Medicaid has to provide some information in a sworn statement so that Medicaid can try to locate this person. I've given you the information that they generally ask you to provide if you can. And Medicaid will follow up on leads and, if possible, verify financial accounts, property, and employment. They call this spousal refusal when a person is available to be talked with, but just refuses to give information to Medicaid. I have seen people approved in the event of spousal refusal, but it's really very hard. This earlier information I provided about last known name, last known address, and so forth is when the spouse just can't be found. Very often people don't get divorced. They just go their separate ways. And in this event, it can be very difficult to get someone qualified for Medicaid when you don't know where that still spouse is located. Some property is just excluded. It doesn't count at all. And some property can be excluded, but Medicaid will take a lien against that property. And some property can actually be transferred without creating a penalty. Here are some of the excluded resources: household goods and personal effects, one automobile, the home for the community spouse as long as he or she lives there. And in that event, Medicaid cannot take a lien against that property. The home if a dependent relative other than a child under 21, blind or disabled, lives there. In that situation, a lien may be taken. The home if a dependent child who is under 21, blind or disabled, lives there, no lien may be taken and the property can actually be transferred without penalty. The home if a sibling with an equity interest lives there and was lawfully residing in the home for at least 1 year immediately prior to the applicant being admitted to the medical institution. In that event, no lien may be taken and property may be transferred without penalty. The home if the applicant has a reasonable intent to return home. A lien may be taken but dissolves if the patient actually does return home. Real property where a joint owner lives for whom sale of the property would cause a loss of housing. A lien may be taken on that property. Property essential to self-support, used in trade or business, regardless of its value or rate of return. Up to $6,000 equity value in income producing property, and the remaining equity is a countable resource. Life estates don't count. The value doesn't count and no transfer penalty will occur if the deed dates back prior to 5 years before application. Assets held in a special needs trust are excluded. Real property the applicant is making a bona fide effort to sell, but in that situation, a lien will be taken. Term life insurance with no cash surrender value is excluded. $5,000 titled for burial or designated in a statement of claim form is excluded. Prepaid burial funds worth $5,000 is excluded. And in calculating it, you're looking at that prepaid contract. When you calculate it, don't count the space items such as the plot, marker, casket, vault, opening and closing the grave, because these are completely excluded as a resource. The face value of life and burial insurance policies that have a combined face value of $5,000 or less. The face value is a countable resource, but can be excluded when designated for burial. The cash surrender value of life and burial insurance policies that have a combined face value exceeding $5,000, where up to $5,000 is designated for burial. The amount not designated for burial is treated as a countable resource. Proceeds paid by a long-term care partnership policy, dollar for dollar, every dollar that a partnership policy pays for someone's care will not count toward the eligibility limit for Medicaid. Now, I've provided some information about what partnership policies are. These are policies that meet specific requirements outlined in the Deficit Reduction Act of 2005, containing consumer protection and inflation provisions. There's a financial incentive to purchase a partnership policy in Alabama. In determining eligibility, because Medicaid will allow the insured individual to disregard resources in an amount equal to long-term care insurance benefits paid by that partnership policy for long-term care services received. To qualify for this resource exclusion, the insurance benefit payments may be made for any long-term care services received, including those not usually covered by Medicaid, for any length of time in any long-term care setting. Resources excluded in determining Medicaid eligibility under this provision will also be exempt from Medicaid estate recovery. So that's quite a benefit. Alabama requires long-term care policies to offer graduated coverage in different settings by prohibiting the sale of long-term care insurance policies which provide only nursing home care. I've provided a link to a comprehensive shopper's guide to long-term care insurance written by the National Association of Insurance Commissioners. And for more information about what qualifies as a partnership policy, you can go to the Alabama Department of Insurance resources, and I've given you a link to that. Medicaid transfer penalties is the real sticking point for a lot of people. Medicaid looks back at all financial transactions for 5 years prior to application, and all gifts or sales of property for less than the value assigned by Medicaid is added and divided by $6,400 to determine the months of ineligibility for Medicaid that will be assessed. The penalty begins to run when the person is institutionalized and would otherwise be eligible if it were not for the transfer. I've given you an example here. A second home valued at $175,000 is transferred to a child in January 2017. The parent applies for Medicaid in January 2020, and that's within 5 years. A penalty of 27.34 months would be imposed. That penalty would not begin to run until the parent is in the nursing home and has used all of his resources, and but for that transfer would be eligible for Medicaid. That means someone will have to pay privately for over 2 years during the time it takes for the penalty to run. Gifting is not just giving away property. It is any transfer of any asset for less than the value assigned by Medicaid. An example might be selling a home for less than the tax assessor's appraised value. When you see people trying to sell property, a lot of times they have to reduce the price in order to get some interest in it and get it sold. And this is fine unless the owner is or may become a Medicaid applicant within 5 years. A better plan is to have the property reassessed by the county or to obtain a commercial appraisal if the tax appraised value is over 1 year old. So for instance, a house sold for $35,000 when the tax assessor's appraised value is $52,000 will be a $17,000 uncompensated transfer and result in a 2.65 month penalty. There's more information later on provided about selling property. Be careful of the application timing, and this is incredibly important. So really listen up on this one. A person gives away $350,000 in March of 2015 and then has a stroke in December 2019 and is placed in a nursing home. If that person applies for Medicaid in January 2020, within 5 years, a 54.68 month penalty will be assessed and he won't be eligible for Medicaid until August 2024. If he had only waited until April 2020 to apply, he would have qualified with no penalty because he was past 5 years from when he gave away the money. If property has been transferred, it can be returned to eliminate the transfer, but credit given depends on when the assets return during the application process. If the return occurs after the initial application, once eligibility has been established and the penalty's been imposed, the asset must be returned in its entirety for a single full month to negate the transfer. But prior to the imposition of the penalty, the claimant will be credited with any amount returned. So a partial return can result in a reduction of the transfer penalty that will ultimately be imposed. And as an example, you transfer $50,000 on January 16th, 2021 and apply for Medicaid in February. If the penalty has not yet been imposed, you can return $25,000 of money and cut the penalty in half. But if the penalty has been imposed, all of the $50,000 must be returned to eliminate the penalty. Beware that the way the penalty for transfers work is that you're outside the 5-year look back if you wait until the first of the next month past when you get past 5 years. As an example, a person gives away $100,000 on March 17th, 2016. 5 years ends on March 18th, 2021. However, to be outside the time a penalty can be imposed, you have to get to the first of the next month, which is April the 1st, 2021. This is a really important concept to keep in mind. This is the additional information I gave you about valuation of real property to establish a value different than what the tax assessor's appraised value is for property. And again, there are several different conditions under which you can actually challenge the tax assessor's appraised value. Usually it's that the assessment is over a year old, and then you can get a commercial appraisal. But when property's been sold for less than the tax assessor's appraised value, the lower value sale may be challenged by the realtor, showing that the condition of the property required a lower sales price to prove to Medicaid that the property was not really sold for less than its fair value. An example might be that the property was listed for less than the tax assessor's appraised value because the cost of needed repairs met or exceeded the difference between the tax appraised value and the offered lower value. If proven to Medicaid's satisfaction, then the sale may be approved with no penalty. Now, I have seen that work by requesting a redetermination of the denial and providing that kind of information to Medicaid. Permissible transfers are those allowed by law resulting in no penalty being imposed. Property that can be transferred without creating a penalty include the home when a child under 21 blind or disabled lives there, home when a sibling with an equity interest was residing there for at least 1 year prior to the institutionalization, home when a son or daughter of the claimant who was residing in the applicant's home for a period of at least 2 years immediately before the date of applicant's admission to the medical institution, and provided care to the claimant which permitted him or her to reside at home rather than in an institution or facility. This is a really important permissible transfer. This is rewarding the child who lived with the parent and kept them from having to go into a nursing home. But you do need to understand that it's not as simple as the child lived in the home. You have to prove that a level of care really did prevent this parent who was so sick they would have been in a nursing home if it were not for the care provided by that child for 2 solid years. Another permissible transfer that won't incur a penalty is the transfer of money into a special needs trust, and resources transferred to or to another for the sole benefit of the community spouse or the claimant's child who's blind or permanently and totally disabled. Caregiver agreements are important to understand. A personal service agreement is a legally enforceable written agreement for personal care services to be provided in exchange for anything of value. Now, while the regulations will permit Medicaid to treat payments to caregiver services as a transfer without proper documentation, the agency is less strict about non-relative caregivers. In the case of paid relative caregivers, the agency requires a caregiver agreement. Otherwise, a transfer of assets is presumed to have occurred at the time of the exchange, and a transfer penalty will be imposed unless all of the following are met. At the time of the receipt of the services were recommended in writing and signed by the applicant's physician as necessary to prevent the admission of the applicant to a nursing facility. Such services may not include providing companionship, and related services. At the time of the receipt of the services, the applicant was not residing in a nursing facility. At the time of the receipt of the services, the transfer of the money paid to the provider or relative occurred. And at the time of the receipt of the services, there already existed a written or signed agreement executed between the applicant and provider for the specific services rendered. Now, this is an important thing because what people are doing is trying to keep their relative at home, and relatives very often will provide care and you want them to be paid. The lesson to take from this is that if you're going to have a relative caregiver, don't pay them without a caregiver agreement. Caregiver agreement requirements further include the following. The caregiver agreement must fully describe the type, frequency, and duration of the services being provided to the applicant in such a way that they can be documented when provided, and the amount of consideration being received by the provider. The caregiver agreement must provide that the amount of consideration cannot exceed the fair market value for those services rendered in the community. Rates for those services must be shown to be comparable to the usual and customary rates in the local area. The fair market value of the services may be determined by consultation with an area of business which provides the similar types of services. Services that are provided pursuant to a valid personal services agreement must be documented with timesheets and attendance logs for each hour of services provided. Contracts cannot provide for a lump sum payment regardless of the services that are to be provided, as each service must be individually documented to be justified. Payment must only be for actual services rendered. Any reimbursement for out-of-pocket expenses incurred by the caregiver must be documented by a receipt. Now, it's important to understand that you can sometimes convert countable resources into excluded resources, and you want to do that if at all possible. For example, you might pay off debt on a vehicle, pay off credit card debt. You can make needed home repairs. You can pay off a mortgage. You can purchase prepaid burial arrangements, and you can use money to fund a special needs trust. A lot of times you'll see a couple and one's going into a nursing home, and they're going to have a pretty hefty spend down, even after setting aside what you can for the spouse at home. Rather than using that money to pay for nursing home care, you can get Medicaid quicker if you pay off the mortgage on the home and make life a little easier for the community spouse, pay off the credit card debts, purchase prepaid burial arrangements. But it's really important to be sure that you do all of these things in advance of applying for Medicaid. Another planning tool that people use is the life estate deed. And this type of deed is one where, say the parents give property to a child, but they reserve for themselves a life estate. That means they have the right to live on the property and they can't be evicted from the property. They continue to pay the tax on the property and insure it. And it's their property for all intent and purposes. Yet when they die, that property will automatically be the property of the children without the probate or will or anything of that sort. Now, if you get past 5 years from having transferred that property and reserved the life estate, then there won't be any transfer penalty for this type of deed. And the Medicaid applicant who owns a life estate will have a zero value asset there. They assign a zero value to the life estate. Now, a special needs trust is a long-term, in a long-term care setting, they're particularly useful in accomplishing a spend down while acquiring additional resources for the long-term care resident. Now, I want you to understand there are lots of different types of special needs trusts, including trusts for disabled younger persons and disabled children. But what we're talking about here is a special needs trust with using the money that would otherwise have to be spent down for a person who's applying for Medicaid in a nursing home. In many states, you're not able to do this particular thing, but in Alabama, you can. In a long-term care setting, an applicant can create the special needs trust instead of spending down that money required to be spent by Medicaid on nursing home care. The money is instead put into a special needs trust, and it can be used to pay for special needs not otherwise paid for by Medicaid for the disabled person once he or she becomes eligible. Medicaid eligibility can be immediately established while these funds remain available to pay for special needs. And that might be paying for a private room in a nursing home, paying for sitters, items and services that can improve the quality of life for the nursing home resident. And this could be salon charges, manicures, telephone, newspaper subscriptions, audiobooks, movies, recreation, medical and dental expenses not otherwise covered, special equipment like wheelchairs or specially equipped vans, therapy or rehab services, on and on it goes. Another incredibly useful expenditure for a special needs trust is payment for nursing home charges during a penalty period. Now, for instance, if money was transferred earlier, creating a penalty period, and there's still some money left, you can place money into a special needs trust, and it can be used to pay for care to get the resident through the penalty period. And normally for these types of special needs trusts, we go through the Alabama Family Trust here in Alabama. The drawback to this type of special needs trust is the requirement that on the death of the person for whom the trust was established, Medicaid must be reimbursed for funds remaining in the trust up to the amount that Medicaid has paid for the nursing home resident's care. If the resident dies with money left in the trust after the Medicaid payback, an alternate beneficiary is named to take the remaining funds. The Medicaid application, the link to that was on slide 11, and I strongly recommend that you use the fillable form because applications that are easy to read and reference the attachments and are well organized tend to go through better than sloppy applications that are hard to read and hard to find the documents that are attached. The resident can sign the application if well enough to comprehend, but usually someone with power of attorney or a court-appointed guardian or conservator or a relative completes the application. Someone familiar with the applicant's business will need to gather all the information and documentation to complete the application. An appointment of rep form can be located at a link I have provided. This form is used when the Medicaid applicant cannot sign his or her own application. It can be used by the applicant if capable of signing, or a person with legal authority to act for the claimant, or one without legal authority when the claimant cannot sign. It can be used to appoint an individual or an attorney to represent the claimant. I have given you a list of information that is necessary to provide with the application. This is what Medicaid says they need. And I want you to also realize that very often you have to provide financial records that go back for a full 5 years. The application for Medicaid warns the applicant and sponsor that Alabama makes it a felony to defraud or deceive Medicaid in the application process through false statements or omission of material facts, and that's punishable by a fine of not more than $10,000 or imprisonment for not less than 1, no more than 5 years, or both. And false information may also result in a loss of eligibility and a bar from future eligibility for not less than a year and until full restitution has been made to Medicaid. Applications are filed at the Medicaid district office that serves the county where the applicant lives. I've given you a link to the different offices across the state. Always keep a copy of the original application submitted to Medicaid and send copies of all other documents. Don't send original documents except for proof of citizenship or identity if that is required. Proof of citizenship and identity is not needed if you're currently receiving SSI benefits or are entitled to or enrolled in Medicare. If additional information is requested, make sure you give that information within the time period requested by Medicaid. And if additional time is needed, get that time approved by the caseworker requesting the information. Understand that if a nursing home assists with the completion of the application, it can be uploaded online. Now let's look at a couple of or several post-eligibility concerns. A Medicaid application can't be approved, we've talked about this, for 30 until the person has been in the nursing home for 30 continuous days. And if a person dies before being institutionalized 30 days, no Medicaid payment is ever made. When awarded, though, Medicaid goes back to the month of application and sometimes up to 3 months prior to that time. It can take a while for the Medicaid application to be approved, so be prepared for that. In the case of retitling assets, in the case of a married couple, it's necessary to remove the Medicaid recipient spouse's name from resources set aside for the community spouse before a year passes and the case is up for review. If a spouse dies and the Medicaid recipient in the nursing home is due to receive something from that estate, then Medicaid expects them to get it. And I have provided information here about what is generally required, up to $37,500 from the estate of the spouse who has died. And if the person who's in the nursing home does not try to recoup that money, then it's considered having given that money away. A veteran who begins to receive nursing home care will have his or her monthly pension payment reduced to $90 if the veteran has no dependents, and if the veteran is living in a Medicaid approved facility and the nursing home care is paid for by Medicaid. There is more information available on estate recovery further on in this presentation. When the application is completed, the applicant is warned that the estate of the applicant is subject to estate recovery for funds spent by Medicaid for his or her care. And it's important to understand that an appeal of an adverse determination requires that you file for that appeal within 60 days of the determination. I'm not going to go through all of these potential events. But if you do report any kind of a change in your situation to Social Security, you also have to report it to Medicaid. And it's the responsibility of the sponsor or the person with legal authority to report to the Medicaid district office any of the changes that may affect eligibility for Medicaid. And I've given you an entire list here that you can look through. Remember, the law does require that you report changes to Medicaid, and failure to do so could cause termination of Medicaid benefits and an obligation to repay benefits to Medicaid that were paid that shouldn't have been paid if they had been aware of the information that did not get reported to them. Now, Medicaid estate recovery. Federal law requires states to recoup money spent for some Medicaid services, and the rules implementing this required federal recoupment vary from state to state. In Alabama, Medicaid estate recovery is required from the probate estate for the following expenditures, and that's benefits that were not paid correctly to a person of any age, in other words, to satisfy an overpayment, benefits paid after age 55 for nursing home Medicaid, benefits paid after age 55 for home and community-based waiver services, benefits paid for hospital and drugs for persons who received those benefits in connection with nursing home or waiver services after the age of 55, and expenditures for services received after age 55 for SSI eligible persons who qualify for Medicaid in the community. The provider, attorney, personal representative, sponsor, or case manager is asked by Medicaid to contact Alabama Medicaid Agency's Estate Recovery Section to provide notification of the recipient's death within 30 days of the death. Upon notification of death, Medicaid will send a questionnaire to the next of kin to ask about property the decedent owned at the time of death. Those handling the estate of the decedent who formerly drew benefits have always been under a duty to treat Medicaid as they would any other creditor and notify them. But that requirement is now more stringent and all estates are subject to notice. As of September the 1st, 2019, all estates filed in Alabama must notify Medicaid to give the agency an opportunity to review its records to determine if the estate may be subject to estate recovery. This is true for probating wills, administering estates, and filing for small estate or summary distribution. And the notice is required whether the decedent is ever received Medicaid or not. The agent will have 30 days to file any claim. Agency will have 30 days to file any claim it may have against the estate. Now, it's important to recognize that in compliance with federal law, the Alabama Administrative Code states that nursing facilities must not require a third-party guarantee of payment to the facility as condition of admission or expedited admission or continued stay in the facility. Nursing facilities may require an individual who has legal access to a resident's income or resources available to pay for nursing facility care to sign a contract without incurring personal financial liability to provide facility payment from the resident's income or resources. It's important to recognize that in the past, some nursing homes would try to get a relative to be a third-party guarantor on the bill, and that's really contrary to federal law. It's contrary to Alabama law. There's even case law that states that a lower court judgment in favor of a nursing home on its breach of contract and conversion claims was reversed because admission contract imposing personal liability on the appellant for payment of his mother's charges was unenforceable. So that's important to know. There are a number of requirements for nursing home agreements. Federal and state law provides that nursing home and rehabilitation facility admission agreements and addendums cannot require the resident to waive his or her rights, including under federal regulations and other protections under federal or local nursing home law, nor can the agreement and addendums contradict federal or state laws and regulations. They cannot require or request a resident waive his or her Medicare or Medicaid. Like they can't say, we're asking, the nursing home can't request that you not apply for Medicaid until the resident is first privately paid for a certain period of time. The agreement cannot require as condition of admission that the resident enter into binding arbitration agreement. Entering into an arbitration agreement means that you waive your right to pursue legal action in the court system if you're harmed. Now, there are plenty of nursing home agreements with binding arbitration, but what I'm saying, and you can sign them, but I'm just saying they can't require that. They can't waive or request the resident waive its liability for loss of the resident's personal property. The law requires nursing homes to exercise reasonable care for the protection of the resident's property from loss or theft. They cannot require financial guarantees, which we talked about just a moment ago. They cannot require residents to deposit personal funds with the nursing home. Every resident, unless pursuant to a court order, has the right to manage his or her financial affairs. And while a nursing home cannot require residents deposit personal funds with the facility, a resident may choose to do so through written authorization. Typically found in addendums, nursing homes will request that the resident agree to allow the nursing home to become his or her representative payee for Social Security. This means the resident will lose the ability to manage his or her Social Security payments. The nursing home cannot require a resident to do this. Arbitration agreements must not be used as a condition of admission to a nursing home or as a requirement for a resident to continue to receive care at the facility. Nursing homes must explicitly inform the resident or the resident's representative. It is his or her right to not sign the agreement. This language must also be in the agreement. The agreement must explicitly grant residents the right to rescind the agreement within 30 days of signing it. Provide for the selection of a neutral arbitrator. Agree upon by both parties. Provide for the selection of a venue that is convenient to both parties. Not contain any language that prohibits or discourages the resident or anyone else from communicating with federal, state, or local officials, including surveyors and representatives of the Office of the State Long-Term Care Ombudsman. Review admission agreements and addendums carefully, because you do have the right to cross out provisions that you don't agree with or are otherwise improper. If you have questions about anything, ask. The nursing home is required to explain the terms of its agreement and addendums. Delaying signing the agreement enables the resident to review the agreement carefully, dispute positions, and perhaps secure counsel to review the paperwork. Once in the nursing home, there are only limited reasons a nursing home may transfer or discharge a resident, and failure to sign the admission agreement is not one of them.
Thank you, Jan, so much. That was a lot of information. I know you worked extremely hard on putting that together. We're going to go ahead and open it up for questions. We have till 11:30, so please feel free to ask any questions of Jan. And somebody had asked if they can receive a copy of Jan's presentation. I believe Jan did show the beginning, but we'll make sure that the attendees do receive it. Okay, and right there on your slide is where you can access the evaluation. It must be completed within 24 hours to Carlette Smith. There's her website address as well. And so again, you must complete this within 24 hours to get your 1.5 CEU. Somebody just asked, just to clarify, the life estate deeds have a 5-year look back, question mark? Jan?
Oh, yes, I answered in the chat box.
Oh, okay.
Yeah, they look back 5 years from when the property was transferred. And if you get past the 5 years, there won't be a transfer penalty.
Okay.
And to also answer the question, yeah, this presentation will be at SlideShare and also on our Facebook page. I think that Jennifer usually puts these on the Panda Facebook page as well. But you can get a copy and print it out and have a copy.
And we had a lot of requests. And we always place these on the M4A YouTube channel as well. We are in the process of developing a brand new training for aging standalone website. And eventually all of these and other presentations will be housed on that. And I'll share that. It's going to officially launch May 1. So at our next CEU webinar, I'll be able to share that with everybody. And if you have not signed up for our newsletter that goes out every Thursday, please go to m4a.org and sign up for the newsletter so you can We post all of these and other events that are going on across the state in that newsletter.
There's another question I see where somebody's asking if there's a similar process to be approved for Medicaid waiver. And yes, the Medicaid waiver program has rules that are very similar to what we talked about today, but there are distinct differences. And to be honest with you, the administrative code and the Alabama policy manual doesn't have nearly as much information about the Medicaid waiver process, application process, or the different individual issues, let's put it that way. And I find that Medicaid waiver can be very difficult to get information about, but yes, there's a separate process altogether to apply for long-term care Medicaid waiver.
Okay. And Jan, there's another one. So estate recovery does not apply to people younger than 55 until after they reach age 55. Is that correct?
Actually, there is a provision in Alabama's law that says that people who are permanently in long-term care settings, even younger than 55, that Medicaid can recoup from their estates. There are a number of people who think that is probably contrary to federal law, but yes, you can actually expect Medicaid to come after the assets of people under the age of 55 if they're living permanently in a nursing home. And I should have put that in the presentation, but I didn't.
Okay. And then one last question is, how does Medicaid look at joint checking accounts that exceed $2,000 for Hcbs applications? Example is $4,000 in a joint account when one spouse is applying.
Well, if it's a married couple, all of it would be considered part of that spousal, looking at all of the assets of the spouses. But say, for instance, if you have a joint account, a mother and a son, all of the money in that account would be attributable to the mother unless you could prove, you could track that account that the son actually contributed some of the money in that account.